Court is calling 2024 CR 008361, State of Texas versus John Mark Horton
Scott Sullivan for Mr. Horton, present, right?
for the state. And are you Mr. Horton?
Hello.
Yes. Are you Mr. Horton?
Yes, ma'am.
All right. Counsel, have you received all of the discovery?
Yes, I have, Your Honor.
Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Mr. Horton, did you review the document entitled Application for Community Supervision with your attorney?
Yes.
Did you understand it?
Yes.
And did you sign it?
Yes.
Did you review the document entitled True Bill of Indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented? Are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Horton, did you review the document entitled Court Admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with possession of a controlled substance, penalty group 2, less than 1 gram, as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the
Yes.
court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I do.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Horton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
I couldn't hear.
I'm sorry, has anyone threatened you, coerced you, or
No,
placed you in
no.
fear to get you to enter the plea?
I'm sorry.
That's okay.
His hearing.
Here.
Oh, no problem. Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yeah.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Mm-hmm.
Did you understand it?
Yes, ma'am.
All right. Punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision. There's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Yeah.
Did you understand it and sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Be contained into the package, Your Honor.
Any objection?
No objection.
State, you may be excused.
Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? This document?
Yes.
Did you review that document with him?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I understand.
Did you understand that today the state will not be calling any witnesses? They're going to proceed with just this document that's been presented to the court. Did you understand that?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to and stipulated to testimony. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he's ready to do the community service. As the court knows, this court committed him to lifetime fitness. I think that the recovery.
Oh, lifetime recovery.
Lifetime recovery.
All right, lifetime fitness, I'm not doing that for anyone, unless they specifically ask for it.
No, you came back in great shape. I don't-
Yeah, you did.
Yes, lifetime, okay. I'll just get past that part. We're aware there's some conditions there with respect to, he's got a hernia right now, and I guess they can take care of him on the community service side. Now, this case has had so many different cases. I want to make sure I know where an order is and that I address it. His son is here today. He is, to this point, I told him to take the position to stay away from the son because at one time there were some protective orders, and they might still be true today, and I think they probably are. His son is here, and his son wants him at home. He's available to talk to Corey if he'd like to, and this man is sober and cleaned up, and he's ready to go home and be able to be with his son. If you'd like to talk to him, he's available.
All right. How long have you, well, let me have you, well, you've already been sworn in. How long have you been sober?
Going on 6 months on the 22nd.
All right. And what were your issues with your son that involved a protective order?
I drank a lot of beer.
Okay.
I,
No, that's wonderful.
No, I'm glad you're being honest.
yeah,
So you've been at Lifetime Recovery. Are you still at Lifetime Recovery?
no, I go to Club 12 now.
Okay.
I'm gonna be a member there.
Oh, that is awesome.
He's
So,
got and I think it's 120 days he has to go every day.
all right. Where are you currently living though?
11302 Hiker.
No. I mean, is it a
My
sober
house,
at your home?
yes.
And if I could, I'd just put in, while he's been there, his husband, his son has been staying with someone else.
Okay.
Because he went into that house when he came out of Lifetime about a week ago. And he went there and his son went out.
All right. And what's your son's name?
Jacob Horton.
So I'm assuming there's a protective order in place because you say because it was drinking. Now, there are a lot of people who drink, sometimes to intoxication at their home, but it doesn't result in a protective order. So counsel,
That's what I was thinking. It may have been a condition of bond, or it may have been something got linked up from the days of the protective order on the misdemeanor, the whatever the misdemeanor was.
all right, family violence or criminal
It was-
trial division, does anybody know about?
Hold up, this is where most people don't realize how serious this moment is when he says yes to understanding his rights. He's giving up a jury trial, the right to confront witnesses, and even his right to stay silent. That's huge. Quick question for you. Would you take a plea deal here or risk trial and possibly more time?
Protective order he has where his son is Jacob Horton.
I think it may have been a condition of,
I don't know.
there was a misdemeanor for violating the protective. I think that's what it came from.
Well, what I can tell you, if the misdemeanor court, if there's a protective order there, you probably need to take it up with the misdemeanor court judge.
And I don't think they have.
No,
I'll check into it for him.
I've already cleared up all my cases. This is the only case I have.
And if that is the case, I'll verify this afternoon then.
Well, it's just that sometimes when there's a protective order, it doesn't matter if your criminal case has been cleared up because
Right.
protective orders are civil.
I agree.
Yeah.
And I wasn't sure if there was one.
I don't know if there's one pending or not, but what I can tell you is I'm not going to allow your son to stay with you if there's a protective order out there. That's a hearing for another day.
And I will hustle up and find it.
Okay.
Okay. Please remember, sometimes on that soul stuff, they don't
Well,
invite us.
can I go ahead and just do my 6 months in jail? I'd rather go ahead and just go to jail and get it over with.
Mhm.
I'd rather do that, ma'am.
Well, let me just
My son and me,
Let me explain something to you.
he doesn't have
even-
any place to go.
Here's the thing.
He's got his brother, but his brother doesn't like him.
Don't interrupt the judge.
All right, so this is what you need to listen. And I want you to internalize what I'm saying. It doesn't matter if you were to get 6 months in this case and go and do your 6 months time, you know what would still happen? If there is a civil protective order out there, when you got out of jail, that protective order would still be there and you all still would not be able to live together. That protective order doesn't have anything to do with the 187th District Court. It's a civil matter. A civil court probably enacted that. This case is a possession less than a gram case.
Okay.
I didn't put a protective order on, for you against your son or whatever, because this is a drug case. And there's nothing that would have come to me through a police report that suggests that that you even have children. This police report doesn't mention anything about you having children. All it mentions is that you were day drinking. So,
And by the way, Your Honor, you've said this several times, with so many other cases running around, I've never been able to determine that myself. But I can go to the civil side of the court, and I think I should, and find out how I can advise my client on that. But with respect to this court, as I understand it, there will be no order of
well, what I can tell you is
if it happens.
if there is a civil protective order, and if he violates that, guess what? I'm going to get a motion to revoke, and it's going to say that he broke the law.
No, I got time served on that charge, so that protective order went away as soon as I got time served.
Okay, here's the thing. Those are two separate matters.
I know it was a misdemeanor court 11, and the judge, he gave me credit for time served.
All right, but let me just tell you, protective orders are civil. They're not necessarily criminal. They only become criminal when people are violating them. Then you can get a criminal case for violation of a bond or protective order, but they are civil in nature.
But whenever I got the assault family bond with my son, they put a protective order.
Yeah. So that has absolutely nothing to do with
And they
this.
signed an affidavit of non-prosecution. I actually never assaulted him, but I was drunk and I was a fool.
Your Honor, if I could, I think what I need to do is, I think you can go through with this. And we've requested not to have that condition here, but we have to honor the conditions of a family court. I will do that for him and advise him specifically if there is or is not one.
Okay.
Daniel, like you said, Texas, I'm thinking honestly, I'm not seeing anything on the protective order. I see the violation of bond. I feel protective order case that's currently open. Not seeing the protective order. I'm kind of asking if someone from protective orders can verify that.
Yeah. And that violation bond protective order, that's in misdemeanor court.
Yes, sir.
So that needs to be handled with the misdemeanor court.
So I just don't know if there's an actual protective order that's not verified.
And I think that, if they did, I think they closed.
All right. So are you employed, sir? Are you employed?
No,
And just like that guilty notice, how fast that happened, no dramatic objections, no witnesses, just paperwork and procedure. That's how most felony cases actually end, not with fireworks, but with signatures. But don't relax yet, because now the real issue is about to explode the protective order and his son.
I'm
All right. Retired from what?
63 years old. I'm retired. I worked.
No, I mean, what did you do in your past
worked at
life?
a restaurant for 14 years, but I can't work with a hernia right now.
Okay.
I got it in the county jail.
All right. The court then will find you guilty. Court will sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's a $2,000 fine. That will be probated. Restitution to SAPD for drug testing. $150 hours of community service restitution. And if he brings me proof of the herniated disc that he can't do community service hours, I'll figure out something else.
Okay. Oh,
There's going to be daily sober support meetings until further notice. Proof of employment or disability within 60 days. There should be no employment as a home health care provider or with minors. regular reporting by Zoom or in person, regular random UAs. Make sure he's tested for alcohol. Field visits, one time per month until further notice. Probation, is there anything else?
Would you like us to do a tap?
Yes.
That's enough, John.
Okay, TAP evaluation, follow all TAP recommendations. And probation, if TAP recommends inpatient treatment, we'll start with outpatient treatment. Is there anything else you need from the court to be successful?
Do you need anything else from her to be successful?
No, I really appreciate you having the opportunity to send me over there because the program is an excellent place to get recovery.
Oh, I'm so glad. I think it's a
It
great,
changed my life and my outlook on everything. So I've internally accepted that I can't drink. So that's a big plus for me.
all right, awesome. And if you ever feel like drinking, that's why you pick up the phone and you call somebody, okay? Even if it's to call probation and let them know. All right?
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? You need to say yes or no for the record.
Yes,
All right. Did you sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
yes.
All right, good luck to you. Probation is going to go over conditions with you. And once she's gone over conditions with you, you're free to leave.
Okay,
Thank you.
Really?
Thank you. Court is calling 2020 CR 10018, State of Texas versus Desiree Tina. Can I have parties announced for the record for the state,
Make a motion to the state.
for the defense?
Lauren left in for Miss Tina.
And are you Miss Tina?
Yes, ma'am.
All right, the defense has filed a motion requesting a bond, is that correct?
That is correct, and it's agreed to, Your Honor.
All right, so Ms. Tina is on deferred adjudication, so she is entitled to a bond. And state, what have you all agreed to?
As far as the agreed to bond, $15,000.
Okay. All right, and Ms. Tina, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Desiree Tina.
All right. If you're able to make bond, who will you be living with?
With my father.
All right, and has he agreed to let you reside there?
Yes, ma'am.
And he's present here today, Your Honor.
All right, and where's her brother?
That's him with his hand up. And her mother's here also, as well as her stepmother.
Whoa, did you catch that he just volunteered to go to jail instead of dealing with probation complications? That tells you how emotionally overwhelmed he is. But here's the legal twist: jail time wouldn't even solve his problem. Protective orders are civil, that means they survive criminal sentences. Would you choose 6 months inside or 3 years of strict probation?
Probation, the court is aware of the issues. So the court will grant your bond for $15,000. My other question is, are there any children in the home?
No, ma'am.
So who all is in the home?
Just my father, my stepfather, and myself.
So,
Stepfather.
Stepmother?
Yes.
Okay. All right. I will grant the bond at $15,000. You to reside with your father. What is your father's name?
Caesar.
All right. We're off the record. So what is happening with the motion to revoke?
we would like to reset this for 30 days and come back in 30 days to see if we can reach a possible agreement.
All right. I'll bring you all back in 20 days.
Thank you.
Ms. Ferguson, on this case, can I have a 20-day reset? It'll be set for contested. If it turns out it's not contested, then you need to let probation know.
Of course. Yes, Your Honor.
30th.
All right.
The 30th.
September 30th. And that will be at 9 a.m. And Ms. Ferguson, if you'll give them a reset form. Is
Thank
there
you.
anything else?
No, ma'am. May we be excused?
Yes.
Thank you.
You're welcome. For those of you who are waiting for a jury trial, we're just seeing if there's going to be another family violence prosecutor that is available to assist. All right, court is calling 2022 CR 6395, State of Texas versus Matthew Bjour. Can I have parties announced for the record for the state?
Andrew Harris, Edelman.
Defense?
Doug Campbell for Mr. Bourgeois.
Can I have a file stamp, please, for motion to revoke? Thank you. Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am. Yes, Your Honor.
Are you the same Matthew Dwayne Bjour who was placed on community supervision in 2022 CR 6395 for the offense of fraudulent use or possession of identifying information, 10 to 49 items, on August 29, 2023 for a term of 5 years? Is that you?
Yes, Your Honor.
State?
On or about the 15th day of April 2024 in Bexar County, Texas. My apologies, Your Honor. In Bexar County, Texas, the defendant Matthew Dwayne Bourgeois did then and there fail to report to the supervision officer as directed for the months of February and March 2024 in violation of condition number 4. State waives the remaining violation allegation.
Any objections to the waivers?
No, Judge.
All right, then to the to the allegation of violation of condition number 4, how do you plead? True or not true?
True, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true and sentence you up to 5 years in prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Is there a proposed agreement?
There is, Your Honor. Continue on probation, deny VOV reporting, transfer case to residing county, and complete court-ordered IOP with supervising.
This is a masterclass explanation from the bench. A lot of defendants confuse criminal court with civil orders. The judge is crystal clear. She didn't issue the protective order, and she can't magically erase it. This is why understanding jurisdictions matters. One court can undo what another court created, and honestly, this judge is being patient here.
All right, so which county is this?
Be Chambers County, Your Honor.
All right, so why didn't he report? That's the $1 million question, or maybe the $2 question.
Judge, it sounds like he was living in a different county. It might have been a little bit difficult for him, even though it might have been video reporting. I think having him report in person is a better option for Matthew.
So why didn't he report? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Matthew Bourgeois.
Why didn't you report?
I was having trouble keeping my phone on at the time, and my probation officer understood that and everything and tried to work with me.
All right. So why didn't you go to a payphone or go somewhere else?
It was video.
Well, no, I mean, did you call that officer and say, hey, I'm having trouble video reporting?
Well, he knows that because I had trouble in the past reporting.
No, if he knew that, then why? And this is what call for speculation. But if he knew that you had trouble reporting by Zoom, then why would they file a motion to revoke? And their motion to revoke is based on the fact that you didn't report.
Well, I was able to report. I mean, he knew that I had trouble in the past reporting, and I was able to report eventually. And
What is this reporting eventually? You're required to report once a month.
yes, Your Honor, I know. This was in the previous year, 2000, or it was in probably October, November.
No, this is February 2024 and March 2024. You're not reporting.
Yes, ma'am. But in October, November, I couldn't report.
Judge, this might have been one of those situations where the probation officer might have just got to the point where he was unable to work with my client any longer. And my client would ask that you allow him to move to Chambers or report in Chambers County and appear by video, but in person rather.
All right, any
Because
objection?
what that would do is it would allow him not to have that issue any longer.
All right, any objection to the court reviewing the court summary?
No, Judge.
All right. So in the court summary, this is what it says. And there are various text messages. So your phone being off, if your phone were off, the text message wouldn't go through.
The email.
Yeah, it wouldn't go through.
Um,
And if your phone were disconnected. So it says, in March, counselor called client to try and get him scheduled for his outpatient program, but was directed to voicemail. Counselor left message asking client to call her back and that she will be attempting to call again tomorrow, March 14th. And then failure to report and pay letter was sent. So that's sent by mail, a letter to you. So they've been trying to get in touch with you. And then they did a final warning letter sent to the defendant on March 14th.
so 426, Your Honor.
No, I mean, they sent a letter to you and they also called. So if the call was going to an improper number, they sent a letter to you. And if you were living in another county, then the next question becomes, was he given permission to reside in another county?
Don't know.
I was working out of town.
No, the question is, did the court give you permission to reside in another county? So that's another violation. I'm not going to consider it because it hasn't been alleged, but he wasn't supposed to be in another county anyway. All right, so Jefferson County. And where you were, was that Jefferson County?
I was living with my mother in Chambers.
Chambers. So we have a lot of moving around. His mom is here shaking her head. No, I don't know. Is that his mom?
It is.
She has her hands on her hips. I think she wants to say something.
Didn't work out for me last time, Judge. I think I'll just go with this witness.
Okay. I mean, if you want to call her, you can.
May I ask a couple of questions?
Sure.
How was it that you came to Chambers County or ended up in Chambers?
Because my mom didn't want me around the people I was living with.
And she lives in Chambers? And that's where you would like to report for probation?
Your Honor, if the judge lets me.
Let
One more chance.
me ask you this. Do you foresee any issues in living in Chambers County if the reporting requirement was transferred to Chambers and was in person?
I have a good support system. I would be with my mother. And I do have a job.
What do you do for a living?
I work construction line.
How old are you?
I'm 34.
All right. So do you want to call his mom? It appears that she wants to say something to the court.
Yes, Judge. What you want?
Sharon Bourgeois.
I'll call Sharon Bourgeois.
All right. You need to stand over there.
Now this right here, this is the turning point. 6 months, sober daily meetings, acceptance, judges look for accountability, and he's finally showing it. You can almost feel the tone of the courtroom shift, but probation isn't freedom, it's structured second chances. One mistake and it's prison. And this is where the story flips again. The judge pulls the receipts, texts, letters, warnings when a probation officer documents communication attempts that destroys the I didn't know defense. Here's the reality: probation isn't optional, it's a contract. So let me ask you, do you think he deserves another chance?